has returned, so
thank you,
South
Franken. Good morning.
Morning.
Congratulations to the administration for, I think, what will be a historic operation when it comes to the operation against bin Laden. I know the President made a very difficult decision, and that is putting boots on the ground, but I certainly think the right decision. What I want to do is sort of talk about the way forward on terrorism issues. I know the KSM going back into military commissions was a hard decision for you. We had respectful disagreements, but I just want to be on the record. I believe very strongly there's a place for Article III courts, and that I'm an all-of-the-above approach when it comes to trial venues. And just for the record, the reason I objected to KSM and the co-conspirators is they'd been held as enemy combatants for so long under the law of war, and I just really was worried about mixing systems. But the Christmas Day bomber, the situation with the Times Square bomber, these are classic examples, I think, of where you could grab somebody off the battlefield and go right into Article III court. Now, let's talk about the interrogation programs we have. I am somewhere between waterboarding and the Army Field Manual. I believe, as I've said many times, I've been a military lawyer for 30 years. Waterboarding as a technique has been talked about among the legal community and the military for a very long time as something not appropriate. And I think going down that road, and I'm sure there was some information gleaned from waterboarding, but overall, the reason we stopped this practice, it was causing a lot of problems for the country. Having said that, I think the best way to interrogate enemy prisoners is to keep them off balance, form relationships over time, but basically have procedures they can't train against. So, Mr. Attorney General, as I understand it, the CIA is no longer involved in interrogation of terrorist suspects directly. Is that true, or do you know?
I'm not sure that that's accurate. I perhaps get back to you on that, but
here's what and check my homework here. The executive order the President issued shortly after taking office took off the table the enhanced interrogation techniques that are classified in the Detainee Treatment Act. And now the only techniques available to us are in the Army Field Manual. They're online. So I would urge you to look at that. I just think it is a mistake to deny the CIA the ability to use classified techniques in the Detainee Treatment Act that I helped write, because the enemy needs to be kept off balance. So if you could look at that and get back with me. And it's my understanding the CIA, after this executive order, no longer directly interrogates enemy suspects, terrorists. Go ahead.
One thing I'd say, Senator, is that you know, when the changes were made with regard to the techniques that could be used, the intelligence community was canvassed, and they indicated that with regard to the techniques that were no longer to be employed and the ones that could be used, that they thought that gave them adequate tools in order to do their jobs.
But my question is, I believe that the only techniques available to the intelligence community and to our military are the Army Field Manual, and that was never written with a view to be the exhaustive techniques available to interrogate prisoners. It really is a guide to our troops to make sure they don't get in trouble. And if the CIA is no longer directly involved in interrogations, I'd like to know that, if that's true. And if they're limited to the Army Field Manual, I'd like to know that.
See, what gives me pause is that I know that the CIA is a part of the HIG, and
right.
So that's why I'm hesitant. You saying
no, and please check it out. It's just, I want to be on record. It's my belief that the policy today is that the Army Field Manual is the exclusive means of interrogating terrorist suspects. It is online, and that the enhanced interrogation techniques authorized under the Detainee Treatment Act are no longer being used. And my view is that's a mistake. Now, when we go forward with future captures, Guantanamo Bay, we both tried to find ways to create a new prison. I've been sort of out there saying it doesn't bother me that you would create a prison in the United States as long as there's a national security-centric legal system around it, but I think we've lost that argument. I don't believe Guantanamo Bay is going to be closed anytime soon by the Congress. Is that your assessment?
Well, we're going to continue to try to close it, but I think it's going to be difficult given the votes that we have seen in Congress and the sentiment that appears.
And to my colleagues who understand, I think it is a well-run prison now. It has had problems in the past, but the administration working with us, we wrote a new Military Commissions Act in 2009, which I'm very proud of, and you helped write it. So I think we got Guantanamo Bay in pretty good shape right now for all those who want to be reasonable. But given that dilemma, I understand we may have some people in our capture now that might be good candidates for Article III trials or military commission trials that we captured abroad. Where do we put people? If we caught someone tomorrow that would be a terrorist suspect, an Al-Qaeda member, if we caught Zawahiri, you just named the person, where would we put them?
Well, I guess it would depend on the charges that we could bring. Certainly if we have an Article III case that we can bring against them, we can put them in any of the federal facilities that we have.
What if you had an enemy combatant that you wanted to hold for, extensive interrogation, lawful, but you wanted to hold them? Where would you put that person?
Well, we have overseas facilities that we can make use of for, interrogation and for detention.
Well, Bagram, the Paul I prison, right. I would really argue that the Afghan government cannot become the American jailer. And if you caught someone in Somalia, if you took them to Afghanistan, that would create a lot of problems for operations there. The answer to me is, and I've asked Special Forces, where would you put these people? I asked the Secretary Gates and asked Admiral Mullen, if you caught someone tomorrow in Somalia or Yemen, a high-value target, where would you put them? And they say they don't have an answer for that because Gitmo's off the table. Do you see anytime soon Gitmo being allowed to be used in special cases of high-value targets that were caught in the war on terror?
I don't think that is our intention. Our intention is to, even given the issues that we have with Congress, to try to close that facility and to try to make use of other other locations that we would have for interrogation, for instance.
I just don't believe there are other viable locations. We need to think this thing through. There are detainees at Bagram Air Base, now Paul I prison, that are not going to be left in Afghan control because they're third country nationals. And we need to find what to do with those detainees, because they're not going to be left in Afghanistan, because I just don't trust the Afghan legal system. So I'd like to work with you on these issues. And one last point. There's a lot of chatter out there about the use of force against bin Laden. Would you agree with me, Mr. Attorney General, that given the intelligence about bin Laden, he promised never to be captured alive?
Yeah, let me make something very clear. The operation in which Osama bin Laden was killed was lawful. He was the head of Al-Qaeda, an organization that had conducted the attacks of September the 11th. He admitted his involvement. As you indicate, he said he would not be taken alive. The operation against bin Laden was justified as an act of national self-defense. It's lawful to target an enemy commander in the field. We did so, for instance, with regard to Yamamoto in World War II when he was shot down in an airplane. So he was, by my estimation, at the estimation of the Justice Department, a lawful military target, and the operation was conducted in a way that's consistent with our law, with our values. If he had surrendered, I think, attempted to surrender, I think we should obviously have accepted that, but there was no indication that he wanted to do that, and therefore his killing was appropriate.
Well, I agree with everything you said, and I'd just like to add one final comment. From a Navy SEAL perspective, you had to believe that this guy was a walking IED.
Exactly.
So if I were a Navy SEAL and I made a positive ID on this guy, I would want to take him down as far away from my teammates as possible. So to those out there who question what happened here, the intelligence and the statements from the man himself said he would never be taken alive, that he had bombs strapped to himself. I think the Navy SEAL team had to believe that the moment they encountered bin Laden, whether he raised his hands or not, that could be a fake surrender, that they were well within their rights, and shooting him as soon as possible probably protected everybody, including the SEALs and women and children. So I agree with you, Mr. Attorney General. This was an operation within the law, and the Navy SEALs acted appropriately, and I am proud of the fact that they protected women and children at their own detriment. They took time to shield women and children from the helicopter being blown up. They protected the women and children the best they could in this firefight, and the moment they saw bin Laden, they had to consider him a threat. And I could not believe a scenario where you would believe he could reliably surrender. So I just want to put my 2 cents worth in there, and I look forward to working with you on these tough issues.
I look forward to working with you, Senator, but I think you make some very valid points that I think people should focus on. It was a kill or capture mission. He made no attempts to surrender, and I tend to agree with you that even if he had, there'll be a good basis on the part of those very brave Navy SEAL team members to do what they did in order to protect themselves and the other people who were in that building. They conducted themselves totally appropriately in that the loss of life was minimal, or as minimized as it could be. Substantial numbers women and children were not impacted during their entry into those buildings, and I'm proud of what they did, and I really want to emphasize that what they did was entirely lawful and consistent with our values.
I totally agree. Thank you.